From the WATE.com Digital Center, answering your legal questions. This is Ask Isaacs. Now, here's Lori Tucker and attorney Greg Isaacs.
And hello, everyone. Bo Williams in for Lori Tucker again this week, along with Greg Isaacs and producer Jeff McClain. Great to have everybody here. Obviously, the big topic of discussion right now is the jury deliberations are underway in the trial against the former president, Donald Trump. And we kind of want to walk you through some of the steps, how things go from this point moving forward. And Greg, first things first, as we wait now for the jury to make their decision, talk to people about. You hear this all the time in the news. You've got opening statements, closing arguments. But do people really understand what's at stake here? What are you trying to accomplish here, as whether you're the prosecutor or the defense? What kind of goes into each of these, kind of compare and contrast these two?
Well, it's interesting, and this is a case that has all the attributes of a high-profile trial. Yeah. You have, former President Trump, it doesn't get more high profile. Sure. You've got sex. You've got a porn star, Stormy Daniels. Then you've got, the bag man, the fall guy, Michael Cohen, who is an admitted perjurer in front of Congress, admitted that he stole from the Trump organization. So you have all of that dynamic, and you know what that leads to? It's a recipe for fiery opening statements and fiery closing statements, and that's what we heard. Now, but here's the difference, and judges remind lawyers all the time. An opening statement is just that. Basically, you are supposed to say an opening statement's like a roadmap. Yeah. And we anticipate the proof will show this. So what you're doing is previewing your case. Argument is not permitted in an opening statement. Now, fast forward. After weeks and weeks of a trial, cross-examination, demonstrative evidence, then you go to closing argument, and that is fiery, wide-open advocacy. In this case, highlighted two different styles. The defense trying to poke holes, and the hyperbole was flying. Michael Cohen, the bad guy from the defense's perspective, the GOAT, the greatest of all time in terms of lying.
The greatest liar of all time, right.
The MVP of all liars. Reasonable doubt, the human embodiment of reasonable doubt. Juxtapose the other side of the courtroom, prosecutors, and this is what you see in big trials these days. They stick to the facts, and they were kind of tethered to their PowerPoint, which at one point I think had almost 500 separate slides. Yeah. So if you're on that jury, you've got the Trump team coming out swinging and going after Michael Cohen and talking about the problems in this case, and then you got the prosecution methodically reviewing the evidence.
But it took a long, long time. I mean, you were talking, that was one of the unusual things about yesterday's session, is that it went and went and went.
And went. So, it's interesting. We've talked about jury selection and what you look for, and now that you're stuck with these jurors, and you are sitting there trying to persuade these 12 people that your client is innocent, or trying to persuade these 12 people that the defendant is guilty. So it's really interesting to see the two different tacks that each side took when they were kind of outlining their case. But Jeff, you had a good point. And when you're doing a closing argument, you're looking at the jury, and what you don't want to see. You don't want to see someone not making eye contact, right. Someone getting bored, or seeing someone doze off. But think about this. The defense argument was 3 hours. So this is somebody talking to you for 3 hours. So you could have gotten in a car, driven to Atlanta, and the person beside you will not shut up. They just kept talking. The prosecution, on the other hand, spoke for 4 hours. I think they finished up about 8:07 last night. So imagine, flying to the Bahamas or whatever on an airplane, and an argument took that long. And we expect the jury to process that and make the right decision.
But then the jury, they weren't done, because this morning the judge, he had an hour and change worth to give him too.
He had to run through.
Hoist that big old thing up.
Here are the instructions for the jury. It's 55 pages.
Don't hurt yourself.
It is. Yeah, I'm trying to hold that. But you get an idea. And he had to read through this. And if I read this correctly, if I read what happened, the jury does not get this. In this case,
in most jurisdictions, they do not.
They do not. So if they have a question, or if they want this, they have to come back and have this sections of the whole thing reread to them. They can't sit there in the back and kind of go back through and say, no, wait a minute. It's read, and it's a lot. They have to digest all of this, and then they go back. But if they have a question, they got to come back and have someone else read it to them again.
And think about if you're a juror, you have listened to the evidence, you've seen the proof, the documents, the cross-examination. Then you've heard these fiery closing arguments, both sides presenting dramatically different pictures of what you heard during the trial.
Yep.
And then the judge, and it's kind of like someone hits, you're going at full speed, 7th gear, and then suddenly, you're just in kind of low gear, and the judge very deliberately reads the rules.
Yeah.
Now think about what you got to do. So you have rules that tell you how to treat the testimony of a witness, whether you can disregard somebody if they've lied or been impeached, the burden of proof, what reasonable doubt means, a unanimous verdict. So, there are 3 possibilities after all said and done. A verdict. Jeff, what are the 3 possibilities? Let me see. You're a layperson.
Well, he could be exonerated, i.e., a unanimous he didn't do it verdict. He could be found guilty, so they all agree that he did, or they could fail to come to an agreement, a hung jury, and that's 3 possibilities there.
Yeah. So you can be acquitted, you can be convicted, or it could be a hung jury, and then it can start all over again because it's got to be a unanimous verdict. But here's kind of the thing. Think about this. You're in one of the most historic cases of all time, and you've like I said, listened to the proof, the witnesses. You've heard fiery closing arguments, and then you've got to digest 56 pages of rules. Then you go to a room, 12 strangers.
Yeah. I was going to say, what happens
take
now
us
that we're in
inside that room.
That's kind of the follow-up to all of this.
Well, we've heard whether politics is involved. Well, politics is involved when you shut that door because you've got to elect a foreman or foreperson. So after you do that, then there is deliberation. So, it's a lot. So, jury service, Abraham Lincoln said it's one of our highest callings of being a citizen, but it's a lot of work, and the consequences are just unfathomable. I mean, so this jury, as we speak, is in that New York courthouse, debating President Trump's freedom.
And for them, you have to think, for them going through this process, and granted, we don't know what they're going to decide or anything like that, whether they go this way or that way or what have you, but still, whatever they decide is going to be dissected. Like I said, this is a high-profile case. That has to be weighing, whether it's supposed to or not, in the back of their minds, from a personal standpoint, because I still have to go out here and resume my life once this is over.
And half of them are going to write books.
Yeah, right. That's true.
And half of them are going to write books. But, it's interesting, in terms of when it's over, you lose that cloak of anonymity that a jury has. And in this case, it was there was not cameras in the courtroom, as we're all aware. But, you're not allowed... no one's inside the jury room during deliberations. It can't be audio recorded. It can't be video recorded. And it's really interesting because, and it depends on the courthouse, but you can walk by a closed jury room during deliberations, and sometimes you hear people laughing, sometimes you hear people screaming, sometimes people crying. So let me just tell you, when they shut that door and they elect that foreman, they go at it. So really an interesting dynamic. But, the judge will also tell you that the argument of counsel is not evidence in the case, but you're the lawyer and you want to make sure you're the one that took this ball across the goal line, that you did it, your summation.
Yeah, well, okay, so we're not going to not speculate on the verdict. But if they're in there and they are debating this, how do they get to either an agreement or a complete disagreement? And then what is the output of that? What comes out of this building? Because you could have potentially they could ask questions. They could there's a whole, all of these jury instructions have to be followed in some manner. And there's also the chance, Greg, that if they don't get an agreement, that it's not, they gotta really try here, right? They can't just say, we're done.
Well, typically what happens is, and you've always got to stay close to the courthouse when a jury's deliberating, because if they have a question, it's written down on typically a small piece of paper. They call you in, and you have an on-the-record informal discussion. Here's their question. Should we just say, you are bound by the instruction? Should we add clarity? And you have a little argument on what the judge should do. And then if he does give some additional guidance, it's written down, and the bailiff takes it back to the courtroom. But in terms of you really got to try. There's something called an Allen charge or a dynamite charge. And if they signal that they may not be able to reach a verdict, this is when everyone's sensory perceptions get really heightened real quick, because you typically don't know the numbers. Am I winning? Right. Am I losing? And then if you're the defense, oftentimes a hung jury's a win, because you're walking out of the courthouse with your client, they're going home. And then the prosecution would have to blow this thing up and start over, spend the time and the money and the effort to do a retrial. So, you listen to how that judge tells the jury they've got to continue to deliberate. And, I've seen judges bring them back in and do it time and time again, which can create other issues. But really a fascinating thing. And regardless of what the verdict is going to be, not be, it's really fascinating in a case like this when you see all the detail that a average everyday American's got to take back there and do this. I mean, think about this, yeah. Bo. If somebody said, here's the rules, 56 pages, I want you to retire for 3 hours and tell me what the right thing to do is.
Right. That's a lot.
And if you'd like to take that challenge for yourself,
we actually have this.
We've posted this rascal on our website. We're just pulling it up there, and you can read through page after page after page. I did think it's rather interesting, the big wide margins. So if you want to make some notes along the side or whatever.
But it is interesting reading to kind of get it behind the scenes.
Absolutely.
If you've never served on a jury, kind of give you an idea, a glimpse at least, into what they're dealing with.
Yeah, and it's interesting. Let's go back to Michael Cohen real quickly. Mm-hmm. And there's actually, and this is what happens, it says, Michael Cohen, you've heard testimony that the Federal Election Commission conducted an investigation into the payment to Stormy Daniels and responses submitted by Michael Cohen. And it just lays it all out. But if you really want to have some fun, have somebody read the jury instructions and time them, and you'll realize how long this process takes. And it takes forever.
I was going to say, between that, the jury being read their instructions, and then going back to what we were talking about earlier, the closing arguments. Mm-hmm. And I know you sent out some information here. I thought it was a very interesting little piece of history here. 1924, defense attorney Clarence Darrow delivered a 12-hour closing argument. This was back in a death penalty case, Leopold and Loeb. It was a 14-year-old boy who was murdered in Chicago, Bobby Franks, which I believe we're nearing the anniversary of that case. But 12-hour closing argument. So, I mean, from the closing arguments to the judge's orders, reading through everything, there's a lot of time.
And that's a fascinating case, not to digress. But Clarence Darrow opted for a bench trial. There was no jury, so he basically looked at the judge for 12 hours and told him what he should do. So who knows? He probably wore him down a little bit. But 2 not guilties in a capital case. But the world is watching. But the most important person now is not the defense lawyer, the prosecutor, the judge. Stormy Daniels, Mike Cohen, the former president. 12 ordinary citizens in that room.
Yeah. Until we're going to talk more about this, be sure to watch us coming up at 5:30 on WATE. And when you get a moment, again, sit down. We've got the instructions, as we just showed you, online. You can read them for yourself. But again, we'll see you here on WATE at 5:30. We'll be talking with Greg more about this.
Yeah, thanks.
Thank you.